Good afternoon. I'm Paul Wallin, Senior Partner of Wallin and Klarich. Probably the one question that we get asked more than any other question is, what do I do when a loved one's arrested? Of course, it's a question that anyone would want the answer to because it's a very stressful time when a loved one's arrested. So we give some very straight advice to help people. And if you listen to the advice carefully, I think you will put it in your memory bank, maybe take some notes, so if God forbid it happens, you'll be ready to help. The first thing I can tell you is don't panic. Because if you are the one going to help someone who's been arrested, the worst thing you can do is panic, because when people panic, they go into freeze mode or they make bad decisions. That's number one. Number two, what you need to find out is what jail is your loved one going to, or what police department. Now, if you were present when the loved one was arrested, we'll say your son, then you're going to know they were arrested by a certain police department. And they're going to be going likely to that police department to be booked and printed and put in either the local police jail or transferred to a local county jail. But now you'll know. And that's the important first step, to be able to tell the criminal defense lawyer that you're going to be hiring to help. The next thing you're going to want to find out, of course, is what are the charges and what is the bail amount. To understand why that's important is you need to understand how bail works. And many of you who have never had to experience helping someone in jail might not know. If someone's arrested for a crime, there is a bail schedule. The bail schedule is developed by the Superior Court judges in every county. For example, domestic violence is a very common crime that people are arrested for. And for a felony domestic violence, generally, the bail in California in most counties is $50,000. That means that in order to bail the person out, you would have to pay a bondsman $5,000 for their fee, and you would have to give them some sort of collateral, because in case the loved one doesn't show up in court, the bondsman has to pay the county $50,000. Well, most bondsmen are not willing to take the risk of posting the bail unless they have collateral from somebody in the family in case the person doesn't show up in court. However, it is normally not a good idea to consider bailing someone out until first you have retained an experienced criminal defense attorney. And that's because the criminal defense attorney should be able to analyze what's going on, see the exact charges, and tell you, number one, whether he believes the bail could go down, in some counties by talking to a detention release officer, or in some counties waiting until the first court date in 2 or 3 days and ask the judge to reduce the bail or release the person on their own recognizance, which means without bail. If that happened, then you would save $5,000 to a bondsman. Another reason to hire or consult with a criminal defense attorney is because if a criminal defense attorney refers you to a bondsman, number one, you'll know that bondsman is reputable. That means reliable. And also, you get a discount. It's called attorney referred bail, and it means you get a 20% discount. Well, on a $50,000 bail, by hiring the lawyer first, you just saved yourself $1,000 in bail bond fees. Another reason to hire a lawyer first is because the lawyer can analyze the charges, and it may be that the lawyer thinks that when the case goes to court for the arraignment, that the judge is likely to raise the bail if the district attorney asks. Well, if you posted $50,000 bail and spent $4,000 to a bondsman, and at the first court appearance the judge raises the bail to $200,000, then you've lost your money. And now you're going to have to post another bond. So it's normally not wise to rush and post bail until you've conferred with a criminal defense attorney. No different than if you were thinking about going into surgery, you likely wouldn't go into surgery until you consulted with a very experienced surgeon and possibly got a second opinion from another surgeon. These are very serious charges when people go to jail and have felonies what they're facing. Another critical thing you need to know in terms of what happens when a loved one is arrested is that they're entitled to 3 completed phone calls in the state of California within 3 hours of their arrest. Well, why is that so important? It's so important because you might not know where your loved one is. He might just not have come home, or you might have got a very cryptic short message, "I was arrested," and click. Or maybe someone in the family says, "Hey, I think your son got arrested. Someone told me that at a party." Now you're freaking out. Well, luckily, it's likely that your loved one is going to call you as one of those 3 calls. And this is important information, extremely important. It does not matter if it turns out that your loved one is completely innocent or completely guilty or somewhere in between. You cannot discuss the facts of the case in any way, shape, or form with your loved one when he calls you from the jail. That is because in almost all cases, those conversations are taped. And any statement that your loved one makes on the tape that could incriminate them can be used against them in court and could lead to their conviction down the line when the case goes to court. What you can discuss with your son or daughter or loved one is, what jail are you in? Are you feeling okay? Don't worry, we're going to be getting you a lawyer. Please be safe, calm down, we're on it. We're going to be bailing you out. Be patient. That's what you discuss. If they need medication, that's something else you discuss. But you discuss it with the lawyer. You can discuss it with your loved one who's in custody, whether they have their medication and whether they've taken their medication. And if not, you discuss it with the lawyer, and then there has to be a discussion between the lawyer and the jail people to make sure they get their medication. So that is a very, very critical bit of information. After someone's arrested, if they do not bail out, then within 72 hours, in most cases, they must appear in court for their arraignment. That is critical, because if you can't bail them out, in some cases, the district attorney may not have time to file charges in time. And if they cannot, then your loved one must be released from custody. Of course, when you hire a criminal defense attorney, they jump on the case immediately, and they go, obviously in most cases, they go talk to your son or daughter, and they find out what their level of culpability is, and if possible, they confer with the district attorney who'll be filing the charge and see if they can convince the district attorney not to file charges or file lesser charges or agree to an OR release. If charges are filed at the arraignment, then, and your son or daughter haven't been bailed out, then at the arraignment, there will be a discussion of bail. The judge will read the charges. Your son or daughter will be told by the lawyer exactly what the charges are, and then the DA can ask for a certain bail amount. It can be higher or lower than the amount that was first put on the case. And of course, your lawyer will argue for your son or daughter for a lower bail or a release without bail. And the judge will decide. And then right then, if it's all put together, because you've hired an experienced lawyer and the bondsman's involved, if the bail gets lowered, or in sometimes not, the bondsman and often can bail them out right from court. And then sometimes they can be released from court or soon thereafter. Another thing I need to tell you about this is that if in fact you are going to bail your son out, do not expect to pay the bondsman the money and within 20 minutes he'll be bailed out. That's not reality. Jailers are nice people, but they do not move quickly, especially when they are going to have to release someone they think is guilty of a crime, or just because they're overwhelmingly busy, or for any other reason. We advise that expect somewhere between a 4 and 10 hour delay from the time the bondsman is able to post the bail until the time your loved one is released. And another question is, well, how do I know when he's going to be released? And unfortunately, the answer is, in most cases, you don't, which means very often a very, very long and sleepless night for the loved one of the accused. Very often the person has to literally wait in the car and then fall asleep in the car, and then the person walks out of the jail and then he'll see the car, or he has a cell phone and you call him or he calls you and say, I'm out. Then you just go pick him up, and he's going to be tired and he's unfortunately going to be smelly, but he is going to be free. But that's just the start of the case, ladies and gentlemen. Now the real work starts. This is great information for you and loved ones, what to do when someone's arrested and how you can bail them out. But it's just the start. The reason you need an experienced criminal defense law firm like Wallin and Klarich to help you is because we've done this for almost 40 years, and it doesn't matter if it's a drunk driving or murder. We've handled cases like that, hundreds of them, thousands in some kind of cases. And we'll be there for you if you need us. You can always call us on the phone and we'll have a free consultation at the beginning. And one thing for sure, we'll give you good, solid legal advice and we'll hopefully calm you down. So it was my pleasure giving you this advice. Hopefully it's helpful. Hopefully you'll be wise enough to share it with your friends and family. So if God forbid this happens, you'll be ready. Have a great day.